to order now. The next bill up will be Senate Bill 405, and the Secretary will read.
Senate Bill 405 by Senator Miller of the 40th and others, a bill entitled An Act to amend Part 3 of Article 7 of Chapter 3 of Title 20 of the OCGA relating to the Georgia Student Finance Authority so as to provide for grants for certain eligible students enrolled in an institution of the University System of Georgia and for other purposes. Mr. President, Senate Committee on Higher Education offers the following substitute to Senate Bill 405, a bill entitled An Act to amend Part 3 of Article 7 of Chapter 3 of Title 20 of the OCGA relating to Georgia Student Finance Authority so as to provide for grants for certain eligible students enrolled in an institution of the University System of Georgia and for other purposes. Amendment 1 by Senator Miller of the 40th offers the following amendment. Amend the Senate Higher Education Committee substitute to Senate Bill 405 by deleting line 46 and inserting in lieu thereof the following. Week during the semester and maintain at least a 2.3 grade point average, provided, however, that a student athlete shall be exempt from the employment requirement imposed by this code section during the period beginning on the first day of the month preceding the month in which the first competition of the regular season occurs through the last day of the month in which the final competition of the regular season or postseason competition occurs. Amendment 2 by Senator Tate of the 38th and others offers the following amendment to amend the substitute to Senate Bill 405 by striking lines 45 and 46 and replacing them with remain eligible to receive such a grant. A student must maintain at least a 2.3 grade point average. That concludes the order.
Chair recognizes Senator from the 40th. Senator from the 28th, if you'll approach. 28th, if you'll approach, please.
Thank you, Mr. President. I don't think this bill will take quite as long as the last one we had, folks. Dealing from Senate substitute to SB 405, LC 21595-4S. Basically, as you all know, we've had the merit-based scholarship with a hope for a number of years. It's been very, very successful. And what this bill does is take things a step further. It has nothing to do with a lottery. It is not funded at this point in time, but basically provides for something that we're the only state probably in the South without this, a needs-based scholarship for young people with a grade point average 2.3 to 2.99999, if you will. There's also requirements coming out of high school. There's one of 5 other requirements, a certain ACT score or an SAT score or a certain performance on the AP or baccalaureate exams. You can pass a pathway assessment or do a work-based learning experience. What makes this bill unique is the fact that for someone to get this financial aid in college, they're going to have to work 15 hours a week each semester while they're in school. And this basically came out of working with the Southern Regional Education Board, and it's a model called shared responsibility. And people will get up to $1,500 a semester after their Pell Grant. Will apply for tuition as well as mandatory fees. We figure right now about 17 of our 29 institutions would qualify for this. I have a fiscal note, but I also have some numbers from the SREB, which I think may be more relevant. They're higher. If we did this for first-year students, it will cost about $5 million. If we do it for all 4 years down the road, it would cost up to $40 million. And we can probably serve about 28,000 young people. Other than being the right thing to do, it also allows us to get the workforce developed here internally within Georgia. And that's very important because right now our colleges, 4-year colleges, can probably provide about half of what we're going to really need in the next decade. There was no opposition on this bill in committee. There was a real good point raised from the gentleman from Savannah. What about student athletes? So that's why you see the First Amendment. For the season that they're participating in, they will not have to work for that particular season, including postseason in case we end up playing the senator from the 39th's favorite team sometime in the postseason here in Georgia. So I ask you to support amendment number 1 for that reason, because I think it was a valid exception to the bill. And I do think this is a great opportunity for us. You know, it's interesting to me, Georgia State University has had the Panther grants for a number of years, which has probably been, they're a national leader in graduating African Americans. And I'm going to close it with this, and it's a pretty good statistic. It puts things in perspective. Georgia Gwinnett College, in August, 13,200 students registered. In September, that number is reduced to 12,400 students. They lose 800 students for maybe less than $1,000. And we've been educating these young people through 12th grade. We spent over $100,000, and it seems ludicrous to me that we don't give these people further opportunities. But again, I urge you to support this bill. As I said earlier, it's a first that you've got to have a sufficient grade point and maintain that grade point, and you got to work. What a unique concept. With that, Mr. President, I will answer any questions.
You do have a question. Chair, no, he waves off. Senator waves off. Okay, you have spoken to the bill. You've also spoken to amendment number 1. Is that correct, Senator?
Yeah, amendment number 1, that's correct. What it does, it allows for an exception for someone playing a collegiate sport during the semester and the season in which they're playing. Just that particular. They got to work the second semester. So if they're a football player, what they're doing in the program counts it towards work, because they're putting more than 15 hours in, I guarantee you that. But the next semester, they've actually got to work in order to get this grant. And the second amendment, which is coming from the senator from the 41st, it does away with the work requirement, and I think that's a real mistake. I would not support amendment number 2. Thank you, Mr. President.
Senator from the 26th is recognized for a question.
I apologize, Senator. I didn't know you were asking a question.
Well, I apologize to you. Senator, would you yield?
Yes, sir.
When you put the work requirement in, I have a problem with that, because usually when you put it in and it's at the school, they pay minimum wage. And if they're in school and they're going to work, they might go to a restaurant where they can wait tables and earn a little bit more than minimum wage. So if you put this in, that kind of hinders that kid from doing it. Isn't it true? I did it when I was going to school.
Well, I will tell you, Senator, I'd have to disagree with you, because I don't have any dollar requirement of how much money they earn. It's the fact that they're actually working. And we've got the federal government involved in this program because it's got a Pell Grant. We've got the state involved with it, but given a grant. We've got the institution involved. We've got parents or guardians involved. And, this is for people making less than $48,000, okay? And then we got the student involved. And again, I think it's a good basic premise that people understand that they've got a personal responsibility. They got some skin in the game, for lack of a better expression at this point. And that's why I think it's a good requirement. It makes things different. We're not just giving money away. One member of my particular caucus said, well, we're just doing welfare. I said, no, we're not doing welfare. We're giving people options here. We're going to do a better job with our workforce. And we're teaching people, by working, they actually learn how to come to work on time and do critical thinking and dress right and get personal responsibility. And I think that's a good thing for a young person. So I would have to disagree with you, sir.
With the senator yield?
Yes, sir.
Senator, isn't it true that I attended school on the Pell Grant?
Yes, sir.
And it also true that I got a Student Plus loan.
Yes.
And I walked on and made the football team. Then I didn't have to pay anything because they gave me a scholarship. But I didn't work. I booked. I booked. I did not work. I booked when I was in school. Now, isn't it true?
I believe you might have missed what I said, that I've got an amendment here that if you are participating in a sport, an intercollegiate sport for that particular semester, i.e. football in the fall, that counts as work. I'm not asking you to do both. You might have missed that because I don't know if you were in the room. But I have an amendment that exempts people paying intercollegiate sports for the semester of which they're playing that sport.
Would the senator further yield?
Yes, sir.
Senator, isn't it true? Some of these young folks might have a learning disability. Not that they are dumb, but a learning disability. And isn't it true that they need to spend the time in instruction and working on the grades rather than being out there working on a job, which means that then they are not putting the right kind of time in the studies?
Sir, I can't really answer that question because I would have to, with an individual. But I will tell you one thing, that I think each institution, okay, will be able to define what they define as work-based, and I think they can help that young person find something that would be acceptable for that particular person, because these grants will go by institution, and there's a finite amount of money, and whatever they are allocated, that's it, and they determine at the institution level where the grants go, and I think they would assist those young people because of their particular needs. What I'm telling you is, if we do this program down the road, I can give 28,000 additional people the opportunity to go to college. And right now, they don't have that opportunity. And I think that's a good thing.
Gentlemen, Senator Yield, for one question.
Yes,
one
sir.
more question. I understand what you're talking about. But isn't it true that a lot of students do not have the capacity to do both? And that's to work at their grades and work. And isn't it further true that I happen to be one of those students who had to get the Pell and had to get the Student Plus and played football as a walk-on and got funded with a scholarship? And it is further true that I graduated not cum laude, but O laude.
Senator, after we've been here since 10 o'clock this morning, I just will yield to you on that line because you got the one of the day, and I will yield the well on that.
He's yielded well. You want to take another question from the senator from the 21st? No, he's yielded. He has yielded, and let the record reflect. Let the record reflect. The senator from the 26th is the most decorated collegiate athlete and professional athlete in this body. I'm telling you, he's a legend, and he is our friend. Okay, senator from the 35th is recognized to speak to. No, I'm sorry, 38th. I misread the. It looked like a 5 on my. 38th. 38th is recognized to speak to amendment number 2.
Thank you, Mr. President. Thank you, colleagues. Amendment 2 is pretty much been addressed by the senator in the 26th. The work, having to work, when we want people to get out of school, I want them to have greater than a 2.3 grade point average. I want them to get a good education. I want them to spend their time studying, learning, doing what we gave them that grant to do, so they can become contributing members of society and do the right thing. I think requiring them to work isn't a good idea. They could get an internship in the summer. They could do other things, but to actually put a requirement in here to work, I really just don't believe that that is what we should be legislating. And I guess really the whole thing was when the senator from the 40th said, some of his caucus said, welfare, that's what the problem is. You feel that it's welfare. It is not welfare. It is helping a young person get a good start in life. And that's what we should be doing. We talked about children this morning. These are a little bit older, but we want them to get a good start in life. So I would suggest that you vote positively on amendment number 2. And of course, if there are no questions, or if there are questions or no questions, I will yield the will.
There is a question
Okay.
friendly question, I assume, by the senator from the 41st who happens to co-sign your amendment.
Senator Yield?
Yes, I'll yield.
Is it not true the author of the bill, the senator from 40th, has an amendment that would allow some flexibility for those going to sports? But your amendment would allow flexibility, for instance, if a young person had a mother who was ill, was unable to take care of themselves, a father who was ill, that they had to spend time taking care of them, but they didn't have a paid job. Your amendment would allow for a lot of conditions in the family that many Georgia citizens face every day, and would be an improvement in helping our young people be educated.
Thank you, Senator. I agree with that. If there are no more questions, I yield the will.
No more questions. Okay. Okay, we're, so let me have the Senate's attention for just a moment so everyone understands. We have amendment number 1 and amendment number 2. The two are in conflict. You would have to vote down amendment number 1 in order to take up amendment number 2. If amendment number 2 is adopted, then number 1 is adopted, amendment number 2 would be out of order. It would basically be moot. Chair recognizes Senator from the 41st. What purpose you rise?
Would it be appropriate to have an amendment that would amend 1A to include both exemptions?
I think if you did that, then it would be in order, yes.
Would the intent be,
Well,
would you want me to
but-
suspend and rewrite that, or
Well,
could I do the intent and have it?
Let me,
1A?
your amendment 2 eliminates the work requirement.
Correct.
And no, yeah, and amendment 1 provides an exception to.
I understand. So therefore, we would have to vote down 1, but if we
Yeah.
adopted 2, we
Uh-huh.
would be also taking care of people in both situations, whether they wanted to do athletics or they wanted to take care of a family member with multiple sclerosis and were
Correct.
unable to work.
Correct.
Thank you, and I think I commend the body. Is it not true that we should vote down Amendment 1, get to 2, and take care of all situations that are applicable?
Very, very good. Senator has spoken. All right, the question now is on amendment number 1. All of those in favor of amendment number 1, rise, stand, and be counted. If you are in favor of amendment 1, rise, stand, and be counted. Really? All those in favor, vote aye. Those opposed, no. Secretary, unlock the machine. On the adoption of amendment number 1, authored by the senator from the 40th, the yeas are 33 and the nays are 16. Amendment number 1 has been adopted. Therefore, amendment 2 is now ruled out of order. Question now is on Adoption of the committee substitute as amended. Is there objection? Without objection, the committee substitute as amended is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection to agree in a Porter committee which fair will pass the bill? Chairs none. Porter committee is agreed to. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage by substitute, the yeas are 44, the nays are 5. And this bill, having received Rex constitutional majority, is therefore adopted. Secretary now will read Senate Bill 363.
Senate Bill 363 by Senator Brass, the 28th, and others, a bill with title enactment, Chapter 2 of Title 21 of the OCJ, relating to elections and primaries generally, so as to provide for the time for opening and closing of the polls, to provide for the tabulation of advanced voting ballots in the same manner as absentee votes under certain circumstances, and for other purposes. Mr. President, Senate Committee on Ethics offers the following substitute Senate Bill 363, a bill with title enactment, Chapter 2 of Title 21 of the OCJ, relating to elections and primaries generally, so as to provide for the time for opening and closing of the polls, to provide for the tabulation of advanced voting ballots in the same manner as absentee votes under certain circumstances. That concludes the order.
Chair recognizes Senator from the 28th to present the bill.
Thank you, Mr. President. Ladies and gentlemen of the Senate, present to you Senate Bill 363. This bill simply allows counties to begin their tabulating of advance voting ballots an hour earlier than they currently do. You will find that in Section 1. The current law allows for the absentee ballots to be counted starting at 7 a.m. on the day of the election. We're simply extending that to the advance voting as well, but they cannot be tabulated until 6 p.m. They still remain confidential until 7 p.m. And Section 2 closes all polls at 7 p.m. Current law allows for cities with population more than 300,000 to stay open till 8 p.m. And this simply eliminates any confusion on the day of the election. So we are closing everything at 7 p.m. And with that, Mr. President, I will be happy to take questions.
There are no questions, Senator.
Thank you.
Hold on a second. I'm sorry. The senator from the 20th, late arrival from the senator from Perry, has a question.
Lord.
If you would yield.
Young Senator, will you yield?
Maybe.
Is this your first bill?
It is not.
Okay, just want to be sure.
We can pretend it is.
No, actually, we prefer not. Thank
Good
you, though,
choice.
Senator. Good.
Thank you.
Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection? Agree in a Porter committee which fair will pass the bill. The chair is none. The Porter committee is agreed to. Shall the main question be now put? Of the objection, chair is none. Main question is ordered. Shall this bill now pass? The question is on to pass the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. on the passage of the bill by substitute, the yeas are 32 and the nays are 16. This bill, having received requisite constitutional majority, is therefore adopted. Would like, let me have the Senate's attention for a moment. Would like to ask the Senate to suspend the rules without objection so the Finance Committee report can be read. You would, huh? What? Senator from the 41st, what purpose you rise? Would you like to approach? All right, we'll move on to the next bill, Senate Bill 74.
Senate Bill 74 by Senator McCune the 29th. The bill will be titled an act to amend Code Section 1511-684 of the OCGA relating to conduct of a hearing for the petition of an unemancipated minor seeking a waiver of the parental notification requirement for an abortion and appeal so as to provide for clear and convincing evidence as the proper standard of proof and for other purposes. That concludes the order.
Chair recognizes Senator from the 29th. Present the bill.
Thank you, Mr. President. It's my privilege to bring you Senate Bill 74. This is a fairly simple change to our code. I do want to take a moment to explain what we're trying to do here. Georgia has a parental notification law as part of our statutory law with regard to abortion. In the normal course, it requires that parents be notified in the event that a minor child is seeking an abortion. There is a judicial bypass option available where the minor child may petition to the juvenile court to have that notification requirement waived. And you'll see at lines 14 through 19, the waiver occurs if the court is convinced that the unemancipated minor is mature enough and well enough informed to make the abortion decision in consultation with her physician, independent of the wishes of her parents, or, not both, but or that notice to a parent or guardian would not be in the best interest of such minor. So we're not changing what has to be shown. What we are changing is the standard of proof. There's a 2013 Court of Appeals case that articulated the legal standard to be preponderance of the evidence. And I had a constituent come to me with great concern that given the gravity of the decision that's being made here as far as bypassing parental notification, that a clear and convincing standard would be more appropriate. For those of you that aren't familiar with the various standards of proof, you have preponderance of the evidence, you have clear and convincing evidence, which is an intermediate standard, and then you have beyond a reasonable doubt, which is typically used in the context of a criminal prosecution. Clear and convincing evidence, one of my colleagues pointed out to me earlier today, it's found in our code over 1,000 times. It's been used quite often. There are 15 other states around the country that use a clear and convincing standard. Actually, the majority of states that have a standard in their statute have chosen to use clear and convincing. So that's really all we're attempting to do here. I think this is a good public policy to make sure this shouldn't be a coin toss. This shouldn't be a close call that a judge is making. The judge ought to have more than just a preponderance of evidence. The judge ought to have clear and convincing evidence in making that decision to bypass notifying the parents. With that, Mr. President, I'll yield to questions. If there are no questions, I'll yield the will.
There are no questions, Senator. Chair recognizes Senator from the 22nd.
Thank you, Mr. President. I'll actually be brief. In opposition to this particular bill, not from the standpoint of not wanting parents to be notified, because that already exists, but more from the standpoint that the clear and convincing evidence standard actually is not properly defined in a way that we could know exactly what the judges are going to be looking at. When we look at this standard today, by the preponderance of the evidence, it basically means that the young lady can show what's required, that she's mature enough or it's not in her best interest to relay that to her parents. When we go to a clear and convincing evidence standard, and as the author was correct, it is used throughout the code. But here's the key point when we normally use clear and convincing evidence standard. When we normally use it, it comes about where there's been a battle of evidence, quite frankly. In this situation, you're not going to have a battle of evidence. It really should just be the young lady with her physician making the case why she should be able to do the judicial bypass. For instance, in OCGA 5112.5.1, for punitive damages, we have a clear and convincing evidence standard to determine if somebody has to pay punitive damages in a civil case. It is then defined that for clear and convincing evidence to take place, the person must show, the plaintiff must show, that the defendant acted with willful misconduct, malice, fraud, and oppression. It gives us a benchmark of what actually is being used for clear and convincing evidence. For instance, when we talk about the fact that if you want to do a guardianship in Georgia, clear and convincing evidence is also used. But first, even before you get to that point, the first steps are that you have to have a written report that is filed. You have to have that filed under oath. You have to have a summary of all the different evidence. You have to have a description of the ward's mental state. That is step one. And only after that, if probable cause is found, then you have a hearing where clear and convincing evidence is then used. So as we start to see, clear and convincing evidence is used, but it is used where you have other evidence, a tremendous amount of evidence to actually balance and weigh. You have opposing parties. In this situation, you do not have that. Not only do you not have opposing parties, in this situation, we're not clearly delineated what constitutes clear and convincing evidence. So if it's on punitive damages, we know it has to be willful misconduct and malice. If we know it's going to put someone through a guardianship, we know all the steps that we have to go through. First, we have to show the ward's mental state. We have to summarize that state. We have to have all of this under oath. And then, and only then, do we have a hearing where we determine whether that person should be placed under clear and convincing evidence. I would also mention that in the case of Motts versus Hall County, which is a Georgia case, which dealt with involuntary sterilization, the court said that you only use the clear and convincing evidence standard when you are trying to, when you maintaining a substantial individual right, a substantial individual right. So in this situation, we'll be using the clear and convincing evidence standard to actually possibly limit a substantial right. The right to exist, to have right to choose with parental notification exists in our law. That is a substantial right. This would be the first time we're using clear and convincing evidence to actually limit someone's substantial constitutional right. So for two reasons I oppose this bill. Number one, we're not properly defining clear and convincing evidence. Yes, we use it throughout the code. Yes, we use it in case law, but each time we tell you exactly what constitutes this clear and convincing evidence. We don't have that here. And then secondly, it'll be the first time that we're really using it to limit a person's constitutional rights. With that, I'll yield for any questions.
You have a question. Chair recognizes
Yes.
Senator from the 42nd.
Thank you, Mr. President. Will the senator yield?
Yes.
Senator, can you explain a little bit about what the purpose of the judicial bypass statute is? First of all, isn't it constitutionally required, held by courts to be a constitutional requirement?
Correct. It is
And-
a go ahead.
No, and then so if you'll tell us a little bit more about what is the purpose of that constitutional requirement?
Well, the purpose is, well, you start from the proposition number one, that of course a woman has the right to right to choose to have that particular procedure, abortion procedure. The courts have said, well, when you're dealing with someone who's a minor, that there ought to be some restrictions, and that restriction should be, should a parent be notified? And so then they say, well, yes, a parent should be notified unless you can show that it's not in her best interest, or that she is mature enough to make that decision, and she actually goes to a court to make that case to a court, and that is done by normally through the preponderance of the evidence. And so that is the purpose behind it, to ensure that she keeps that particular right. And also one of the purposes behind it, and it's in this statute, is that we want to keep it as basically secret as possible. We don't want this to go out. If you change it to clear and convincing evidence, and you see what we have here, when you have all of these different factors that play in, someone else really needs to come give some other testimony about why she is not mature enough, or why it is not in her best interest. That goes completely against the purpose of these statutes.
Senator, why might it be in the best interests of this youth to keep this a secret?
Well, it could be in the best interest because many times in those situations, and of course, let's be fair here, I believe there's only been like 42 even requests in Georgia over the past year or so, but you could have a molestation situation, you could have an incest situation, you could have violence going on at the home. Those are the reasons that many times that takes place. So those are some of the reasons that that would take place.
You mentioned there were 42 applications last year. Is that what I heard you say, Senator?
I believe it was only about 42.
Are you aware how many out of the 42 applications, how many were granted?
I believe it was 36 or somewhere around there.
So then it would be that 6 were denied.
Yes.
Senator, would you agree with me then that it is not, the current procedure then does not yield a rubber stamp out of judges if we are seeing denials?
Correct. It certainly does not yield a rubber stamp, but I think even more importantly than that is I think it shows with those numbers that you don't have a situation where you have minor young ladies all just in hundreds just running out. What we really are seeing in Georgia is that really most like what is taking place is persons are talking to their parents. Persons are actually having conversations, and that's a good thing. But what we are saying is when that situation arises that that cannot happen, which apparently is very rare, then the standard should just be preponderance of the evidence.
So it is a very rare instance where this is even utilized, which is, I agree with you, a good thing. What would be the danger of making the standard of proof harder to meet?
Well, the danger, of course, would be in those situations that we just talked about. If it was violence in the home, that's one danger, obviously. And then, of course, there's even the broader constitutional danger that are you chilling the right? That right does exist. It is there. It is the right to have an abortion under these circumstances, and are we chilling that? So there's actually two things that are going on. Number one, from a direct practical standpoint is, are we causing somebody who's facing violence or incest or some type of sexual assault in the home, are we putting them at danger? And then we have the broader question on the constitutionality itself.
Senator, would you agree with me that it could put some young, obviously teenage women in physical danger if we raise the burden of proof? Could that happen?
I think that could certainly be a possibility because that would very well me. But the reason why you probably see it so rare is that persons are actually having these conversations. So it's someone who actually cannot have these conversations with their parents or guardian.
One last question, if you're willing, Senator. Do you know, are you aware of how common it is among our 50 states to use clear and convincing versus how many are using preponderance of the evidence in the judicial bypass
I believe
procedure?
the author said about 15 states were using clear and convincing, but it's not necessarily meaning 15 and then you have 35 that do not, because some states do not require it at all. So in the minority would just be the 15.
So we would be in the minority. We would be much more restrictive than average. Thank you, Senator.
Thank you. No other questions? I'll yield well.
Do you have a question, Senator, from 29? No? Okay. No further questions. Senator from 29th, what purpose? You rise.
Mr. President, I move the previous question.
Senators move the previous question. Is there objection? There is objection. All those in favor of the previous question, rise, stand, and be counted. Rise, stand, and be counted. Chair recognizes Senator from the 41st.
Is it not true we've had less than 30 minutes to debate this issue, and this is an important issue to Georgia citizens, and we should do our job and stay here and work to get it done?
I think the senator had an opportunity for that as well. Are all those in favor of engrossment, of moving the previous question will rise, stand, and be counted? If you are in favor of moving the previous question, the senator from the 29th is moved. Reverse. On the motion, the yeas are 29, the nays are 15, and the previous question has been ordered. Question now is on Does any other senator wish to speak for or against the bill? Is the objection agreed and reported to committee which failed to pass the bill? Chair is none. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. Chair recognizes Senator from 34th. State your inquiry.
My mic on? Yes, thank you. Is it not true that we did not fully debate this issue and women's voices are not being heard? And for the 18 years I've been down here, every year there is a bill on the same subject matter talking about women, their bodies, and their rights, yet we are calling off the debate because the guys want to go home. Is that not true, Mr. President?
Senator has great passion for which she speaks. On the passage of the bill, the yeas are 33 and the nays are 17, and this bill, having received requisite constitutional majority, is therefore adopted. Secretary will read Senate Bill 373.
Senate Bill number 373 by Tippins of the 37th, a bill to be entitled Act to amend Code Section 15-6-2 of the Official Code of Georgia annotated, relating to the number of judges of superior courts, so as to provide for an 11th judge of the superior courts of the Job Judicial Circuit. Mr. President, the Senate Committee on Judiciary recommends this bill do pass. Senator Stone of the 23rd.
That completes the order. Recognize Senator from the 37th? 37th to present the bill.
Thank you, Mr. Pro Tem, members of the Senate. I'll be very brief. This bill allows for an additional Superior Court judge in the Cobb County Superior Court Circuit. There has been determined that the case judge ratio is above that level at which they would earn this. This has been appropriated in the FY19 budget, and it's also in the Cobb County budget, and it kicks in January 1 of 2019 to give people the time to make accommodations for this. If there's no questions, I'll yield the wheel.
No questions, Senator. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill pass? The question is on the passage of the bill. All those in favor shall vote yea. Those opposed shall vote nay. Mr. Secretary, if you'll unlock the machine. Senators, while you are voting, I will direct your attention to the gallery. On your left-hand side, we have the senator from the 37th's lovely wife, Ann, and his son, Nathan. Please rise. The First Lady of the 37th. On the passage of the bills, the yeas are 39, the nays are 0. This bill, obviously receiving the requisite constitutional majority, is therefore passed. At this time, I'd like to recognize the gentleman from the Classic City, the Majority Leader, Senator from the 46th.
Thank you, Mr. President. I move the Senate stand adjourned until 10 a.m. on Monday, February 26th.
The senator has moved that we stand adjourned until 10 a.m. on Monday, February 26, 2018. Read the announcements, Mr. Secretary.
Rules will meet upon adjournment in 450 of the Capitol. That concludes the order.
No other committee meetings. We stand adjourned. So, all those in favor? All those opposed? The ayes clearly have it.